I, Akansha of BLLB 1A, take this opportunity to welcome you all on behalf of Center for Legal Studies, Gita Rhythm International Business School on this Tuesday. Gita Rhythm International Business School was established in the year 2004. GIFT is affiliated to Guru Gobind Singh Indraprastha University, Delhi, and approved by All India Council for Technical Education. Ministry of HRD, Government of India for its management courses, and Bar Council of India for its laws. The institute conducts programs of MBA, MBA International Business, BBA, BBA LLB, BA LLB. The institute is accredited as A Prime grade by NAAC and assessed as category A++ by Joint Assessment Committee of Government of Delhi and Guru Gobind Singh Indraprastha University. The institute has been rated grade A Prime by Cabinet Audit Cell of GGSIT University consecutively for past 8 years. GIFT has also been rated number 2 by the Time Free School survey in 2018, 2019 and 2021. Now I request all of you to kindly have a look at the video for the glimpse of the institute.
A promise is what you make to yourself. A promise to explore, innovate, and achieve. It's a driving force that leads you on a path of success.
Disseminating the knowledge of new concepts which are applied in the industry. Going by this agenda, the institute is going to conduct today's session on art of drafting a contract. I'm profoundly delighted to introduce our esteemed guest, Honorable Justice Shri Prakash. Sir is presently practicing as a senior advocate at Supreme Court of India. He got his bachelor's degree in law in 1984 and got enrolled as an advocate with the Bar Council of Delhi. He started his practice on civil side in District Court and Delhi High Court. Sir got selected in Delhi High Court Judicial Services in 1997 and he started as an additional district judge handling civil cases. After practicing for about 13 years, he decided to join judicial service and got elected in Delhi Higher Judicial Service in 1997. He secured second rank. And when additional district judge had been doing civil cases, he was posted as additional special judge in year 2000 and 2003. And as a special judge in year 2006, where he dealt with the cases under the Prevention of Corruption Act 1988. Then he was posted as Registrar High Court of Delhi in year 2006. He served as a district judge second come ASJ, North District 2009. Elevated as an additional judge of High Court on 17 April 2013. His lordship took oath as judge of High Court of Meghalaya on 23rd May 2016 and transferred to Delhi High Court on 26 November 2017. Sir, I on behalf of Center of Legal Studies GIFT heartily welcome you to this program. We are honored to have you here. Before taking the session forward, I would request our Director Sir, Professor Dr. P.M. Jori, to welcome our guests for the samples. Now, I would like to request Sir to take the program forward.
Very good morning. I believe that all of you are students of first semester?
Yes, yes, sir.
Have you gone through the contract act?
Yes, sir.
So what is contract? Anyone?
Agreement between a promise.
No. Not at all.
Agreement.
Section, please see section 2H.
Which is enforceable by law.
Yes, that is the definition provided in section 2H. An agreement which is enforceable at law is a contract. And now the question would be, what agreement is enforceable at law? And what contracts are voidable and what contracts are void? That is also mentioned in section 2. If you have read it, please see section 2. Definition is very clear. Before coming to the subject, how to draft a contract, we must know what is contract and what is the legal binding contract. Kindly see section 2F. This calls reciprocal promises. Then G says an agreement not enforceable at law is said to be void. An agreement enforceable by law is a contract. Then I says an agreement which is enforceable by law at the option of one or more of the parties thereto, but not to the option of the other or others, is a voidable contract. So now you were talking about consideration, promise. Consideration is one of the essential ingredients of a valid contract. It is not a contract. What constitutes contract? Before coming to the draft of a contract, we must know what are the essential ingredients of contract. Two parties, yes. No, not willingness. No need of any willingness. There should be offer. It includes. First ingredient is offer.
Then acceptance.
Then acceptance. And then consideration. That's all. If all these three ingredients are there, it constitutes a valid contract. And if any one of them is lacking, then it is not a valid contract. Suppose offer is there, and there is a counter offer. Unless the counter offer is accepted, it is not a contract. If simple offer is there and simple acceptance is there, then it will constitute. If counter offer is given by the other side, then no, not acceptance. For this purpose, we must know a contract is a legal binding agreement between the parties to create mutual obligations that business and individual use to protect their interests. Contract outline the specific terms of agreement for a transaction. They can also dictate legal consequences if a party tries to break the agreement. Contract can be written or verbal. It is not necessary that should be in writing. It can be verbal. But second question would be, if it is verbal, how you will prove it? That is a different matter. But it can be oral. How contracts are formed? What are the characteristics? What a document must contain to be considered a contract? Who is eligible to enter a contract? Just now I have heard minority, majority. That is a very different issue. It is there, though it is important. I will not say that it is not important. But that is not the only ingredient. Who is eligible to enter a contract? What consequences? Yes. And section 11 says, I will come. Briefly I will come to that and then draft. What consequences exist for violating contracts? What a contract can require of signatories. So essentially, contract law explains when contracts exist, when they are enforceable, and what the wrong party can do if the other signatory ignores the terms of the agreement. Now, we will come to characteristics of a contract. First one, there are three essential ingredients just now I have told you. First one is offer. The offer must be clear, specific, and voluntarily opportunity provided by one party to another party. The offering party or you can say offerer will present particular terms to the offeree. These terms should include a clear declaration of intent to enter a contract. That should be clear. If it is ambiguous, impossible. The offeree information indicating who is eligible to accept this contract, to whom you are saying giving the offer. Third one is what the offerer intends to provide in the contract, such as goods or services. I think you all must be knowing that contract of personal service very difficult. To prove it, to enforce it, legally how you will enforce it? If A has agreed to perform contract to draw a picture, and suppose he is unable or he is no more, then can it be enforceable? Certainly not. Specific bar is there in the contract. Then second essential ingredient is acceptance. Contract must include a clear acceptance of the offer. As offer should be clear, it should also be clear. Acceptance can take three forms. Words. Most contracts are accepted through verbal or written statements that the offeree agrees to enter the contract and abide by its terms. Then second is actions. Contracts can also be accepted by taking action. For instance, suppose a contract states that taking an action like clicking a link or using a website constitutes acceptance. After reading the contract, people who perform those actions agree to the terms by default. It is not necessary that he should say, I accept it. If he has clicked it, then he has accepted it. Then third one is performance. There may be some situations whereby you have performed it, amounts to acceptance. Even if a contract does not designate a specific action as constituting acceptance, it is possible to accept a contract without words. If a restaurant receives a good shipment from a supplier and uses it to make food, the restaurant has entered into an implied contract. By using the goods in its normal course of business, the restaurant and supplier can assume a contract was created and the restaurant owes the supplier payment for that food. So he should have been deemed to have accepted it. Then third one is necessary, most essential is consideration. The consideration of a contract is the value that is being provided. This value need not be in money, need not be present. It can be past, present or future. It can be financial such as loan. It can be property such as goods delivered. Or it can be services such as maintenance or protection from harm. A contract does not need to include a specific type of consideration. Who is competent to contract? Anyone can tell? Who is competent to contract? अभी आपने बताया था. Not only 18 years, section 11. Yes. Section 11 is very clear. It says every person is competent to contract who is at the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So, can you tell me what is the age of majority? How you will determine? Where it is so mentioned? Indian Majority Act, Section 11 itself says so. So we must know the basic things where we should find it. Who is a good lawyer? Not that who knows everything. I am sorry to say that nobody knows everything. Even I do not know everything. But you should find out where to trace it out. Where in the Indian majority act. If you know about it, then you will open the act and you will know. You don't know. What is the age of majority? Who is of sound mind? You can know. But if you do not know where to trace it, you are not a good lawyer. Very clear. Even as senior advocates, or I can say sometimes judges also, not supposed to know everything. Every day we have to learn. Every day we have to read the books. I will tell you one instance. When I joined the service, as Delhi Higher Judicial Service, I was told, we know CPC, CRPC, IPC, Evidence Act, everybody knows. And suppose after complete trial, if you have convicted a person for any offence, not necessarily 302 or 304B or 304, any offence, and you have fixed the matter for consideration of sentence, you know that murder case, you have to sentence him up to life or death. Only 2 sentences. But still, I will suggest you, and I have learned it, that before sentencing a person, you should read the section. Chances of mistake are there. How? If death or life, there is no other third, then you will say that why we should read the section? Necessary. Because section says life or death and or fines. If and is there, you are bound to impose the fine. If or is there, it is optional. So before sentencing a person, you should know what are my powers. That is the reason. आपको ये मालूम होगा कि कहाँ देखना है, आप फर्स्ट सेक्शन खोलोगे पता चलेगा। आपने कहा कि मुझे मालूम है मैं कर दूंगा, गलती हो सकती है। एंड और इतना कंफ्यूजिंग है। अब देखिए आप डेथ सेंटेंस में, when you are convicted a person, you have convicted a person under section 302, and you are imposing the sentence of death. But still you have to impose fine. Even after death sentence, you will be fine. Why? Because it is a requirement of section. No, requirement of law. Section says and fine, not all. This is not your discretion. So you should read. In all other offences, sentence is there and up to. Though I am going outside this topic, contract act, like section 167, CRPC, if you have read it. CRPC, nahi aaya? Then no need. Then coming to that other, come to contract act. Section 12 says, what is sound mind for the purpose of contracting? Every person is competent to contract who is the age of majority. It says about section 11. Then 12 says a person is said to be of sound mind for the purpose of making a contract if at the time when he makes it he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. If he is unable to decide his own interest, then he is not of sound mind. He is not competent. Then section 13 says consent. 2 or more persons are said to consent when they agree upon the same thing in the same sense. You all know Contract Act was enacted in 1872, but still it is a good law. Very minor amendments, no major amendment is there. CRPC has been amended in 1973 and even thereafter so many amendments are come. But in this Act 1872 no amendment. And it covers all the possibilities. Now section 14 says free consent. Consent is said to be free when it is not caused by coercion as defined in section 15, or undue influence as defined in section 16, or fraud as defined in section 17, or misrepresentation as defined in section 18, or mistake subject to the provisions of section 20, 21 and 22. Consent is said to be caused when it would not have been given but for the existence of such coercion, undue influence, fraud, misrepresentation or mistake. Now section defines, I think it is not necessary to consider here that what is coercion, what is undue influence, what is mistake, misrepresentation, everything is there in the act. Now come to what makes contracts valid. Does not vitiate public policy. All parties are able to consent. A fundamental part of the contracting process is confirming that all parties involved are eligible to consent. This is known as having the capacity to enter the contract. Certain groups are never assumed to have the capacity, including minors or adults with mental limitations. All parties understand and agree on the terms. A contract is considered binding when all parties give genuine consent to the terms. It is only possible to provide genuine consent if the parties involved understand what the agreement means, including what they will receive and need to be. Mistake or misrepresentation in the contract prevent parties from giving genuine consent. Whether an error in the contract is an actual mistake or a purposeful misrepresentation, it still means that the misled party can sue to have the contract nullified. The contract's nullification would occur because the misled party did not understand the agreement's actual terms and therefore could not consent to them. Now, when contracts require legal enforcement, once an enforceable contract is signed, all signatories are bound to the terms of the agreement. If one party fails to live up to the terms without a legal valid defense, they have breached the contract. There are two main ways to be in breach of contract. Failure to perform. First one is failure to perform as promised. If a signatory has agreed to deliver payment by a specific date and does not, they have failed to fulfill their contractual obligations. This is a material breach or failure to accomplish a core element of the contract. 2. Acting to prevent the other party from performing as promised. Suppose the offeree has agreed to deliver goods to a specific location, but the offerer refuses to let the delivery vehicles onto the property. In that case, the offerer prevents the offeree from fulfilling their obligation and is in breach of contract. When someone breaches a contract, what should be the consequences? What the other party can do? The other party can sue them for compensatory damages, as mentioned from section 73 onwards in the Contract Act. He can sue for compensatory damages. The wrongdoer party has usually lost something of value because of the other signatory's actions. Contract law allows them to tally up the value of what they have lost and sue to have the breaching party compensate them for their losses. Contract law is critical to modern business. Contract law is a fundamental element of maintaining business relationships and protecting your organization. understanding what makes a contract valid and the consequences of violating an agreement can help keeping your company on track and prevent legal conflict. Well-written contracts support better partnerships and mitigate risk both inside and outside your organization. Implementing contract law can be complicated, especially if your organization manages many agreements. A functional contract life cycle management solution can help you deliver. Now the other aspect is obligation of the parties. Dispute often occurs because the contract does not adequately specify the obligation of one of the parties. If agreement does not say what are the obligations, then dispute will come. Think through what one wants to be delivered as a product and how progress will be measured and tied to the obligation to make payment or deliver product or services. It should be clear from the agreement itself. Then third one is payment terms. When goods or services are being secured, requirement of prepayment, if any, is to be clearly brought out. When does the contract require the party to pay? Pay in advance fully or partially or await performance. It is surprising how many times such contracts get progress. Such clauses are acceptable as long as the contract is managed in that manner, ensuring adherence to the requirement for documenting by amendment any changes. Then termination clause is also necessary. Termination prior to the end of the term may be breach of contract. Suppose if the agreement is for 2 years to be expired in December 2023, before that if you are terminating it, it will be breached before the end of the term. Failure of the other party to meet its commitment. Effect of refusal of party to perform promise only or occurrence of an event such as of access to key personal or products or for convenience of the party, a party no longer wishes to continue the relationship. Maybe agreement to sell, maybe collaboration agreement. Nowadays that building is being constructed in collaboration with the builder. That is also an agreement. So all the terms should be there. But termination clause can be problematic in assuring fair treatment of both parties. So they must be clearly stated. Now the question is, what will happen if one of the parties has expired? What will happen upon death of either party? क्या होगा?
void हो जाए.
Void होगा या voidable होगा?
सर voidable होगा.
Void क्यों? वही मैं पूछना चाह रहा हूँ. Void क्यों होगा? सही है?
voidable तो option पे होता है ना, void तो यहाँ पे.
Yes, बिल्कुल ठीक है. So promise by the representative of the promisor. In case of death of such promisor before performance, unless a contrary intention appears from the contract. If the intention of the contract agreement is something else, then matter is different. If it is capable of being performed, then legal heirs are also bound. For example, I have entered into an agreement to sell this book. Tomorrow I am NOV. If the book is available, my legal heirs are bound to supply it. That can be enforced. So it is voidable. Suppose if the book is already lost, already sold by me before I die, then it. to be executed. So it is necessary to mention that what will happen. You should know. Another example we can take. A promises to deliver goods to B on certain day. On payment of rupees, suppose 1,000. A agrees promises to deliver goods on payment of 1,000. A dies before that date. A's representative are bound to deliver the goods to B, and B is bound to pay rupees 1,000 to A's legal representatives. It is not necessary that my legal aids are bound to deliver the book, but the purchaser is also bound to pay the money. Now another illustration we can take. A promises to paint a picture for B by a certain date at a certain price, any amount. A dies before that date. So, can it be enforced? Because it is an act of personal service. The contract cannot be enforced by A's representative by B. It is a contract of personal service. I have agreed. I promise to draw a picture by certain date. Not my legal heirs. They cannot. They may not be knowing how to do it. So it is not very hard. Now we should come to the drafting. What are the learning objectives? How to use active and passive voice, sentences, tenses, conjunctions, dates, values to express your intention without ambiguity. It should be clear, straightforward. How to avoid jargon and keep your context clear, tight and understandable. We should not use such words which are difficult words, which is difficult for others to understand. Sometimes we try to mention such words which everybody does not know, and if other party is unable to understand, no purpose. So the words should be clear. We should avoid the jargon words. When and how to use subjectivity or include subjective standards in a contract to benefit your interest. And different levels of review of contracts. There will be reference to different kinds of clauses in a contract. So you must keep referring to the chapters in the next module if you are unable to understand the meaning of a clause. Now in English there is active voice, passive voice. Passive voice makes sentences complex and indirect. We should avoid. In this structure, the doer of a particular act or a job, that is the person on whom the responsibility is placed, is often difficult to identify. On the other hand, framing a sentence in active voice intrinsically ensures basic clarity. Agreement should be, as far as possible, active voice. For instance, the start date of the construction is to be decided. It is a very confusing statement if it is written in passive voice. Start date of construction, which does not clarify that who will decide the date of construction. When you will decide? Does not mean anything. If we write the same sentence in active voice, the contractor will decide the start date of construction. This makes it clear that it is the responsibility of the contractor to decide the start date of construction. Contractor will decide it. That's all. Should not be vague. It is appropriate to use passive voice only when it is more important to mention and focus on what was done or not done, and where the person responsible is not required to be identified or focused on. So similarly, we should avoid use of archaic language and Java. It means if the language is not correct, then what is said is not what is meant. If what is said is not what is meant, then what ought to be done remains undone. Now, what are the examples of archaic words? Words like however, thereafter, herein are not commonly used in English language, but are excessively used in contracts, policies, notices, and replies. One should abstain from using such words as they are effete substitutes of proper pronouns. Sometimes they also lead to ambiguous references. For example, above. If you are drafting an agreement, contract, you will mention above. Above mentioned, aforementioned, aforesaid, before mentioned, henceforth, hereby, herein, hereof, hereto, hereinafter, herein before, herewith, said, same, such, thereof, therewith, whatsoever, whomsoever. Both the parties will be given a chance to argue that it can be this way, it can be this way. You can say in a lighter way that this is the duty of the council. Council will argue it and develop an argument that it means this, it means this. So, if to the extent it is possible, agreement should be clear. Avoid these terms. It is possible to replace archaic words with simpler words, which shows the use of these words and suggested alternatives. Now, I will ask simple question. Hereby, what we should write? If you want to draft a good contract, what will you use instead of hereby? Yes? Can you tell? Each party waives its rights to a jury trial with respect to the transactions contemplated by this agreement. Very clear, no ambiguity. अगर आप लिखेंगे each party waives its rights to a jury trial with respect to the transaction contemplated hereby, confusing है. अगर आप specify करेंगे each party waives its rights to a jury trial, और इसको अगर आप replace करें hereby with the word by this agreement, clear हो जाएगा. Another example you can take, the escrow fund shall be held by the escrow agent under the escrow agreement pursuant to the terms thereof. Here the word is thereof. So we should write, I will suggest you, the escrow fund shall be held by the escrow agent under the escrow agreement pursuant to its terms. Thereof is replaced by the word its terms. Alternatively, determine what thereof refers to and creates a prepositional phrase beginning with the of and ending with the thing to which thereof is referring. Now, another is verb. Choose the verb that are consistent to your intention. Verbs express the nature of the obligation of the parties, and inaccurate usage of verbs can destroy your draft. A few pointers for using verbs. I can see the verb is shall. As a simple rule, use of verb shall to indicate the binding nature of something. If you have used the word shall, it has the binding nature. It is different from may. So shall is a mandatory word, and the subject of sentence should be obligated to do something as a result of shall. The most simple test to see if shall is used correctly or not is to check if shall can be replaced with has a duty to. You can yourself check it whether you can replace this word with the word has a duty to. Use shall to indicate a convent. A party's name should always proceed shall, because name cannot be changed. There is no ambiguity. Otherwise, the word shall is mandatory. And now the other word is may. May suggests a discretion or possibility, but no binding obligation. For example, consider the following clause: employee may get an annual bonus. So whether the employee is bound to pay the bonus? Certainly not, because his employee may get. Shall get, if the word would have been shall, then the employer is bound to pay. Employee shall get it. But here the word is employee may get. So usage of may implies that there is possibility of the employee getting a bonus once a year. Possibility is there. He may get or may not. However, it is not certain. And the employee cannot bring a legal action against the employer if he does not get bonus in a year. No suit can be filed for compensation or claim of bonus, nothing. Because the agreement is there. It says employee may get. The other party is not bound to pay. अगर यहाँ word होता shall get, then he can sue. But since the word is may, not bound, no action. May can also be used to indicate a choice. For example, you can say if the seller makes a misrepresentation or breach of a covenant, then the buyer may pursue all remedies to which it is entitled under the law. Not specific performance, but he can do anything. Recovery, compensation, damages, not specific performance. याद अभी आप specific performance तक पहुंचे नहीं होंगे. Specific performance भी बहुत अच्छी चीज है, अपने आप में बहुत है. In this situation, the buyer has a choice to pursue one or more available remedies. He may go for performance, he may go for recovery, compensation, damages, money, anyone. So the other word we can normally use must in the agreement to sell or any agreement contract. Use of word must denotes a requirement. For example, to avail bonus, the employee must not take more than 15 casual leaves in a year. Must not. The word is must. Here the use of must prescribes a precondition for the employer to be eligible for bonus. If he has taken 16 leaves, not entitled, because it says he must not. Negative clause is there, but the word must is there. Shall not, must not. If that word is there, and if he has used away that more than that, then not entitled. Shall and must have similar obligatory implications. Must is used more as a qualifier or a prerequisite to be eligible for something, while shall is used to impose a duty. This is the difference between must and shall. Now, on the other way, what is the difference between would and could? For a best agreement, good contract, we must know all these things. While mentioning would, could, we must know what is the effect, what are the consequences. All of you are going to be a lawyer at least. We can say. So we must know how to draft a good contract. Big companies, MNCs, or even they are paying so much for contract, drafting a contract only. If the contract is vague, or contract is not specific, or in the contract you have used certain words which are not proper, nobody will be happy. Nobody will pay you. So, we should consider, suppose if a company is not a party to any threatened or pending litigation that could have a material adverse effect on its business or financial condition. Another scenario is the company is not a party to any threatened or pending litigation that could reasonably expect it to have a material adverse effect on its business or financial consideration. In the first scenario, the word was could have. Here, could reasonably be expected. There is a difference between the two. And the other one can be the company is not a party to any threatened or pending litigation that would have a material adverse effect on its business or financial condition. Here the word is would have. So you can say the use of could gives a discretion to the person who has to make the disclosure decision whether the conditions will be met or not. It will be difficult to question the judgment drawn. If such discretion is given, the use of would shifts the discretion from the party making the disclosure to the other side. It also imparts a certain determination. Now, I can say tense. We should pay attention to use the tenses. Use shall, must or will, depending upon the nature of the clause and the context for convenience and closing action clauses. Now, come to another part. The use of conjunctions and to, or, there are other words, and, or, to express your intention. We should use the word, for example, in a purchase agreement, simple clause is, buyer and seller will review the document. Here the word and is used as conjunction to indicate that both buyer and seller will review the document. The clause says buyer and seller, both. simpler clause is, second we can use is that buyer or seller will review the document. Here it is optional, buyer or seller. In first one, compulsory, both. Here it says buyer or seller review the document. Here the word or is used recently and implies that either of them will review the document. Do not use and, oblique, or together. My suggestion is that try to avoid both words at one sense, and oblique or, because it creates confusion. Use either and or. If both are used, it is confusing. You can read it anyway. And or. Then it gives rise to confusion, and lawyer will argue that no, it means this because it is here and oblique or. Another aspect is that values, age and dates, it should be clearly mentioned. While drafting a contract, we should clearly mention what is the value, what is the age and the dates. Time, date and other numbers often quantify the measurements or deadlines for the obligations of the parties and are therefore critical. You need to ensure that such clauses do not unintentionally have multiple meanings in your contracts. Therefore, let us see how to avoid ambiguity with these values. First one is date. Misuse of preposition. Common preposition which lead to uncertainty when used in connection with measurable values that are by, within, between, from, and until. To steer clear of all such ambiguities in a contract, what we should use? We should use before, on or before. Do it by 30th or do it by on or before 30th. After, on or after. And the other one can be not later than. It is not optional, you can do it any time. Not later than. Do it not by 31st, not later than by 31st. That's all. Now we can consider these words in a rent agreement. Normally, every day we use it. Landlord and tenant rent agreement is here. And if in a clause in the rent agreement, it is mentioned that the tenant shall vacate the premises by 15th August 2020. The word is tenant shall vacate the premises by 15th August 2020. Now the word by raises the issue as to whether August 14 or 15 is the last day to vacate the premises. Because in the agreement it is mentioned by 15th August. It is not on or before 15th August. So the confusion would be whether he can vacate on 14th. A potential buyer may tender bids for the target between 1st November 2020 and 15th November 2020. The ambiguity pertains to whether the party can tender bids on the stated dates or not. So, a potential buyer may tender bids for target beginning on November 1st and ending on November 15th. The other one is time-bound contract. Like most contracts have a term clause or clause which stipulates a time period. While drafting a time clause in a contract, we should consider and we should refer to calendar years only. To refer the period from and including 1st January through December 31st of the same year, that is calendar year. Check the ramification of a leap year. Confirm that a future date is a business day by using a perpetual calendar. If parties to a contract are from different time zones, it is suggested to specifically provide for the time zones as well. For example, in a contract where listed securities are placed, the value of the security is calculated at the end of the day based on the stock prices at the close of trading on that day. The trustee is required to measure and communicate if the security falls short of the required amount. In such cases, if the parties are situated in different countries, the time and the time zone when such calculation is to be undertaken daily by the trustee on the basis of the close of the stock prices must be written so that there is clarity about when the trustee is required to communicate the outcome of the calculation every day. Then last one is the age. When referring to a person's age, state the age at which the right begins. For example, the property will be transferred to Mr. X son, when he turns 21. The other one is gender sensitivities. Incorporating gender neutral languages stems from appropriateness and inclusivity. It does not influence legal implications because the interpretation clause in the contract or the General Clauses Act. You know the General Clauses Act is there? Madhuban? If any dispute about the interpretation, then General Clauses Act will come into play. So we can say that it does not influence legal implications because the interpretation clause in the contract or the General Clauses Act states the difference to the masculine includes a reference to the feminine. What would be an example of gender neutral language in policies? For instance, while drafting a leave and attendance policy, writing women are not permitted to stay after 8 p.m. in the office premises. It says that women are not permitted to stay after 8 p.m. in the office premises. Is gender specific. Instead of this, writing this as employees cannot stay in the office after office hours. That would be better. Employees cannot stay after office hours. Without permission of the office management, we can advise it. My advice would be that you can mention it that after office hours, you cannot, no one can stay except with the permission of the officer. The meaning of the second sentence has changed slightly as any employee will need managerial alignment before staying back in the office. The first sentence required managerial alignment only if a woman employee stayed back after 8 p.m. However, such a change in the meaning may be necessary for a gender neutral effect. When you do it, make sure you obtain alignment of your seniors before you change the intended meaning of the policy. Similarly, you can use the word such as personal or workforce instead of manpower. Crew member instead of crewman. Difference is very slight, but it makes a difference. We should use crew member instead of crewman. In the same way, avoid using terminology based on caste, religion, race, culture, religion, reason or language when drafting policies or disciplinary orders. Everything is clear? Now coming to standards of responsibility. Before drafting an agreement or contract, we should pay attention to standards of responsibility. Some clauses in a contract establish a standard of responsibility to be followed by a party. For example, if clause says parties shall try their best to mitigate losses. It says parties shall try their best to mitigate losses. Or parties shall try commercially responsible ways to mitigate losses. First one was try their best to mitigate losses.
I had met you few days back when you had come to the college for the first time, and today I would say that you are so fortunate that you are hearing a stalwart, the judge of High Court, who have drafted many contract judgments and so many things. On the very few days in the college, you are hearing a person who is learned in the subject. I have around 45 years experience, and working with HR, there was no day when I have not drafted a letter, in other words, the contract, where some promise was made, some promise was accepted, and telling about the contract in 1 hour or 2 hours is not an easy task. Putting Gagar mein Sagar. Sir has done a miracle job. He has tried to cover up the big subject for you. And I must say, this is the lifetime opportunity to you. Those who have heard this carefully, they are really benefited. You must take all events in the college with careful consideration. Otherwise, you would be losing. You are so fortunate. I must say that your parents are so fortunate to put you here in this college, where you will find such personality teaching you. You know, some boys were talking in between. You know, the sir has been the judge in High Court. If in his court somebody disturbs, it is contempt of court. Police can arrest. Such persons are talking and you are also doing some murmuring is not correct. You should be careful whenever any guest is there, or to that extent when your faculty is there in the class. Please listen. So I thank you for coming and hearing the important aspect of contract. and the nitty-gritty and important aspect which sir has told are very important. Had I been in your place, I could have noted each and everything, if possible. If you have failed this time, next time be careful. These opportunities will not come, as I said, told you. This is lifetime opportunity for you. So the contract is not a subject which is to be heard in 2 hours. Lifelong you will understand what is contract. So with these words, I convey my sincere thanks to respected sir, who has made it possible to come, accept our request and grace the occasion to address our enthusiastic students. These are the lawyers for tomorrow. Definitely the law has got lot of opportunity, lot of vacancies. And law is a present by the God. You know, the Koch has written the definition. What is law? He said, the law is a present by God and practiced by sages. बड़े लोगों का काम है जो दूसरों की भला करना चाहते हैं, जो पुअर हैं, जो अपनी खुद मदद नहीं कर सकते, उनकी मदद करने के लिए आप लोग तैयार हो रहे हैं. So you are doing some sort of worship, adoration to the God. Be sincere, be regular for your studies. I thank all of you, especially to Vaish sir, who has made it possible, and I would request him that whenever we request, he will be kind enough to grace us and come and teach our students. Thank you, sir. Thank you.